Sorry, my computer broke down. Okay, hello everyone. Can you all hear me? Okay, great. So hello everyone. It's a real pleasure for me today to be able to share this talk of the Human Rights Center titled Argentina's Experience on Trial for Crimes Against Humanity, Limits and Expectations, that is going to be given by a very dear alumna at Essex University from our LLM in International Human Rights Law, Monica Swipe. I was so pleased when we invited Monica to give this talk and she accepted, because for me, really, Monica epitomizes the role model of what one can expect as a professor at Essex to have in a student. She's an inspiration. She's a committed person. She has always had determination. She has passion for what she does, and she has rigor and great knowledge. I remember, and I will never forget, when Monica came to Essex, and just having arrived, she came to my office to talk to me and to tell me already back then, and we are talking about 2006, she said to me in my office, Clara, I really want to go to Argentina. I really want to deal with the crimes that took place during the dictatorship there. I don't know if that's possible. Like, what do you think? Do you think I will be able to do it? I really want to learn about the Inter-American system. And that was just when she arrived. And this seems to have been a dream that she had for quite some time already. And I am so delighted to say that you can see in Monica how dreams can come true. She had the determination to say, I'm going to go to Argentina. She was an Argentinian French national, but she had not really lived in Argentina. She had her Spanish. Her parents, and you will hear her talking, are from Argentina, but she had not been able to build or develop that strong connection that somehow she had in her heart. And she pursued her dream. She left Essex and went to various places, ICTJ and the like, and she continued until she got to Argentina, started at CELS, and then worked at various places, key places in Argentina, until now that she's working again at the prosecutor's office, always following the trials, always fighting for justice. So she's a person that has really done what she wanted to do, with passion, with love, with knowledge, with rigor, and always defending what she believes to be right. So that's Monica. And so I'm really, really delighted, Monica. You really cannot imagine how much. But the other beautiful thing Monica has is her ability not only to be a square-minded lawyer, as many of us are, boring lawyers. She also has that great ability to engage with other disciplines like the arts, particularly theater, writing, to translate in different languages, power of justice, but also the ability to be self-critical about what we do, which I think is something that we all human rights lawyers should do on a daily basis. So for all those reasons, I think Monica couldn't be best placed to share with you her experience. And I am also delighted to have with us Karine Bunot today. Karine is a colleague in many settings. She's working currently for the Global Survivors work as the person that is heading the programs of the Global Survivors Fund. But she used to be the director of the justice desk at FIDH, where actually she met Monica in 2004. And I invited Karine to comment on Monica's talk, because part of Monica's story also comes from that time. I think Karine played an important role in Monica's life. So I thought it would be a beautiful opportunity to bring all of these amazing women together and to hear from them, and to actually project in all of you that inspiration that we should all keep dreaming, that we can turn our dreams into reality, and that we can connect to various dimensions in life, not only the law, but other beautiful dimensions that can have really an impact. So Monica, down to you, and Karine and Monica, thank you so much for being here at Essex with us.
Thank you, Clara. You're too nice, really. Thank you. And I'm really happy to be here, and I'm happy to be with you and with Karine also. And I will try my best to share my experience in Argentina, and not to be too boring. Please excuse me if I make any mistakes in English, but I haven't been speaking in English for a long time, so maybe I've forgotten a little bit. I don't know if there are any Argentinian people listening to us, but please feel free to correct me if I say something wrong. There is no problem about it. I'm working in Argentina since 2008, so I feel it's a lot, but I also feel like I still need to learn a lot about the country. So if there might be some things to correct or to add, don't hesitate. As Clara was saying, I was a student at Essex in 2006, 2007. And at that time, I was really obsessed with the way Argentina was forming a real state policy to treat crimes against humanity that occurred during the last dictatorship in Argentina. For a question of time, I won't enter into the whole history of the fight against impunity in Argentina, because I'm sure you all heard about it or read about it. Just to set up the basics, there was a dictatorship in Argentina in the 70s, with a lot of secret detention centers, victims of torture and forced disappearances, among other human rights violations, of course. Afterwards, there was a Truth Commission called CONADEP, and then a junta trial at the end of the dictatorship in 1985. And in this trial, the judge, the highest rank of the military involved in the dictatorship. But then there was the impunity laws that prevented investigating the rest of the crimes committed during the 70s, then the pardons, and then the truth trials. So I know it seems a lot, and I won't enter into the details. So what I can do is to share a link here with you so that you can read it. It's a book that was written by the NGO called CELS. It's the NGO where I started to work in Argentina, and they wrote a book in Spanish and in English, which is very good. It's called Making Justice, and it's from 2010, and it explains the historical development that led to the reopening of the trials. So this is what I'm not going to tell you today. What I really want to tell you is what really made the difference, and what enabled the reopening of the investigation for the crimes against humanity that were committed during the dictatorship, and the reopening of the trials, is the 1994 constitutional reform in Argentina. Because this reform enabled international human rights treaty to enter into the constitution, and to enter into the constitution with the same hierarchy as the constitution. So this enabled the Human Rights Convention to be applied by judicial, by tribunals, and to by tribunal at national level. So, for instance, we're talking about the American Convention on Human Rights, the the International Pact on Civil and Political Rights, the Convention Against Torture, the American Declaration of Rights and Duty of the Man, the UN Declaration of Human Rights, and a lot more conventions that directly enter into the Constitution with the same hierarchy as the Constitution. And this is very important because with this new paradigm and with the judicial activism of civil society, like for instance, CELS or mother of Plaza de Mayo or grandmother of Plaza de Mayo, we managed to obtain sentences that applied international human rights law and led to the reopening of the trials. For instance, since 2001, we started to have a sentence that stated the obligation for Argentina to investigate and judge serious human rights violations committed during the last dictatorship. So this is really important because what enters into the Constitution, like at the same level as the Constitution, at the same hierarchy as the Constitution, are not only the rules, but also the interpretation of the rules. And what was happening in 2001, for instance, at the international human rights level? In 2001, for instance, in the Inter-American system of human rights, you have very important cases, like for instance, Barrios Altos. Before that, you had Velázquez Rodriguez, if I'm not mistaken. And these cases are very important for the region. And because they stated the obligation for the state to investigate, judge, and repair serious human rights violations committed in its territory. And all these judgments, even though they were for other countries, for Peru and Honduras, I think suddenly they are being applied by Argentinian tribunals to reopen the trial, to say that Argentina has to reopen the trial. And not only the Inter-American system sentences are being used. They also, national tribunals start to use also, for instance, the Joannet principles, for instance, the UN principles on justice and reparation that started, all this field that started to grow at the UN on the obligation of for states to judge and repair human rights violations are being applied by national tribunals in Argentina. But also, for instance, the international customary law too. So Argentina really showed a very big permeability to international human rights law since the reform of 1994. Of course, it took some time because only in 2001 you had the first sentence, and then you have a confirmation by the Supreme Court. You have one first important sentence in 2004 called Arancibia Clavel, and it's a sentence that says that crimes against humanity should not be subjected to statute of limitation because it's a principle of jus cogens. Even though Argentina at that time, even though Argentina during the dictatorship and before, and hasn't ratified the Convention on Statute of Limitation for Crimes Against Humanity and War Crimes. So it's really enables the incorporation at national level of international human rights law, the written and the customary international law also. And then in 2005, you have, of course, a very famous and important case called the Simon case, which applied directly the American Convention of Human Rights and the International Pact on Civil and Political Rights to say that the impunity laws cannot apply in Argentina anymore, and that Argentina has the obligation to investigate and judge and repair crimes against humanity committed during the dictatorship. Afterwards, you have a lot of cases. You have cases about pardons law that says that the pardons that were given after the junta trial should not apply anymore because of Argentina obligation to investigate, and this obligation comes from international human rights law. So this is what enabled really the reopening of a trial in Argentina since 2001, but it started really in 2003, 2005. And these principles are also used by the defense, I want to tell you, because they also ask for a fair trial, of course. So the judge, the Supreme Court, also has to analyze if those trial respect fair trials, and they base themselves in the American Convention, the International Pact of Civil and Political Rights, and so on. So I think this was the cornerstone for the reopening of the trials, the great permeability with international human rights law, and the development of international human rights law in since 2001 with all those principles, the Joannet principles, the Inter-American system, and so on. So I don't want to be to extend myself too much on this, but this was, I think, very important to understand. And I think that Argentinian people do not understand this really. Also, they think that it's the trial reopened, but I don't know if they really understand why they have reopened, because of the incorporation of international human rights law. And the incorporation of international human rights law is still being used in other fields in Argentina. Of course, not only about crimes against humanity. It's also used for other human rights violations. But now we're talking about the crimes of a dictatorship. So what happened afterwards is that there was a very important state policy that started. And for instance, the judiciary, the Ministry of Justice and Human Rights, the public ministry put in place several public institutions, several special units in order to address serious past human rights violation in the country. It's like a landscape of institutions and units and rules to address the issue of crimes against humanity. And the idea of this landscape is that we all work together. We all need each other and we all depend on each other. For instance, in the public ministry where I work now, they created special prosecution units, and there is a big, the head of the unit that is coordinating the rest of the units of prosecution in the rest of the country. So you have special prosecution units in the whole country. And for instance, in the city of Buenos Aires, there are 5 special prosecution units depending on the trial you are working on. So for instance, so how do we divide them? There is a special unit for the crimes committed in La ESMA, which is one of the biggest clandestine center of detention. There is a special unit on the crimes committed by we call it the Primer Cuerpo del Ejército, but it's like a part. The military had divided the country and the city in different parts, and they divided their power into different geographical zones. And so that's why you have sometimes several units, because one of them is based on that zone, the other one is based on other zone, and you have inside each zone several clandestine centers of detention. So for instance, so what we can say for the moment is that mainly the prosecution units are divided by geographical zone and clandestine center of detention. And these units, well, the units of the public ministry, work on trials, on trials that have already been brought to a trial. They are not working on investigation. They are just working on the trials. The investigation is done by the judiciary, the traditional judiciary system, not by the public ministry. They are separated. So I just want to show you some all these special units of the prosecution are coordinated by a head of units. I'm going to show you about this. So this is it. It's called the Procuraduría de Crímenes contra la Humanidad. This is like the head of all these small units, the big head of the prosecution unit. And it's very interesting. I'm showing you the website because the website has a lot of information. They have these units work, they not only coordinate the work of all the prosecution office, but they also write protocols, for instance, to support victims and witnesses. And what I like most is that they do a very interesting statistic work. So they were able to would you say, like to process what is happening in all the trials in the whole country, because there are trials in all the whole country. So it's really difficult to coordinate all this and to be able to know how many people have been condemned, when, why, where, how many people, how many accused died, how many accused are acquitted, and so on, is very useful also to understand what is happening to this justice process. So, for instance, we can read now. It is written in Spanish, so we have more or less 14 years of trials. So, in the last 14 years of trials, there was 250 sentences, and there were among these 250 sentences, more than 1,000 persons condemned and 164 acquitted. I don't know if it's a lot. I don't know if it's, for me, it doesn't seem very much. Like I think, oh, it should be more, but I think it's a lot of work too. And so if we have a look closer at the last number that are from March this year, so we can see, for instance, that in this justice process, we have 750, more than 700 accused died during this process. So if there were, of course, if these people wouldn't have died, you would have much more, you would have over numbers. You would have more person acquitted, more person condemned. So one of the big problems we have in this process is it's too slow. But this is one of the things I want to say, but I will come back to this later. So just to keep talking a little bit about but I really recommend to read, to have a look at the website of Procuraduría. If you are interested to know more about statistic work, I will send it to you here. I'm really fan of the work they're doing. So I was saying before, in this landscape, to address the issue of crimes against humanity, we all have to work together. What does it mean? It means that in the prosecution unit, for instance, we need to work closely with the Human Rights Office of the Ministry of Defense, so the executive power. Because, for instance, they have archives of the armed forces and where you can find the records of the accused sometimes. Sometimes you find nothing, but sometimes you find interesting archives. And it's important that in the Ministry of Defense, you have a special unit for human rights working on the archives. And in the public ministry, in the special prosecution unit, we also work with the program in charge of psychological support for victims and witnesses. This program belongs to the Ministry of Justice, so it's another ministry. We also work with the National Archive of Argentina, which is very important and was very important during this last year of COVID, because we needed to have all the documents accessible online. So because we couldn't go to the office and we couldn't check all the papers of very high, a case is like 20,000 pages. It's a lot. So it's really easier to work with it when you can have access to it online. So the archive is doing a very important work to make it more accessible for the person who works on the trial in the judicial system also. But as I was telling you before, one of the big limits we have is that even though crimes against humanity shall not be subject to any statute of limitations, there is like a biological impunity. That means that whatever we're doing, it's too late. It's too late because we started to investigate 20 years after the crimes. And if we don't investigate as fast as we would like to, also we arrived to, the accused died. So sometimes you find, for instance, a new clandestine center of detention, or not a new one, but you find a clandestine center of detention, you find victims, but you don't have any accused because they all died. So you cannot have a trial. So you have the victims, you have the evidence, you know who were in charge of a clandestine center of detention, but since they're all died, you cannot have a trial. So this is really complicated, because it's also complicated if we want to offer reparation for the victims, because we have to tell them, no, we cannot have a trial. We know the truth, we know what happened, but we cannot have a sentence. So we have a big problem with time, with urgency. Everything is too late. So the accused died, the victims died. I think there are some victims that died and could give their testimony before, so we can use their testimony for other trials. But there are some victims that die and haven't given their testimony, and so we just cannot do anything. The time, one of things, sometimes we say that crimes against humanity are so huge, so complicated, so complex, that we need time to investigate. And because we need time to produce the evidence, I think sometimes it must be true, I'm sure it's true, but after 30 years after the fact, it's really difficult. It's really difficult because it's not like, sometimes you just having luck. Sometimes you just need luck to find an evidence, but you're not finding it because you have a protocol to help you to find the evidence. It's really difficult to work also on secret detention center and on enforced disappearances, because there is a big silence pact between the perpetrators. So they are not given any evidence. So we have more than almost 15 years of trials, and there are very few, very little evidence that were brought by the perpetrators. So it's really like sometimes you have the feeling that you just will not be able to bring truth, even though you have a lot of trials, even though you can identify victims, you can identify some accused, but you just don't know what happened to many of them. One other big limit is the criminal justice system in Argentina, because now it's the criminal justice system in Argentina is just trying to do its best, but it's also working on other cases, and so sometimes it's just too much for the system, because crimes against the trials for crimes against humanity sometimes are very huge. Sometimes it takes 5 years to have a trial, like the ESMA trial, the third ESMA trial lasted for 5 years. So it means that the judges, during 5 years, they have to take care of this trial. And if they take care of this trial, they don't have time to take care of the other trial. And so you just have a lot of trials waiting in the waiting list to start. So sometimes you have like another clandestine center of detention, which is very big in the province of Buenos Aires. It's called Campo de Mayo. And I think like there are 9 trials in the waiting list at the moment to start. So you just don't have enough judges. You just don't have enough persons working in the justice system to be able to attend this huge amount of work for each trial. So it's complicated. But on the other side, which is something I think it's a good thing, and I would say it's a good thing, even though we cannot measure it right now. But I think the fact that the national judicial system had to deal with the trial for crimes against humanity also helped the national judicial system to get better, to improve, for instance, the way it treated victims, to improve its capacity of work. Now we can have access to a lot of documents online, but this is useful for crimes against humanity, and this is useful in general for the justice system. So I think there is a very important impact on the justice system, even though we also suffer from this justice system at the moment. And there is a big limit also, I think, that is that the trials are caught into the political agenda. So really, so at the beginning of 2003, 2005, there was like a very important political support for the trials. And then, for instance, in 2015, when we had a new president, so everything went backwards. So a lot of things that started to work, they just don't have budget anymore. So they just couldn't go on this work, or they started to close, or they just started not to work anymore on some topics. So this is a real problem, because it's too dependent on the political agenda. And we are too slow. There are a lot of cases waiting not only to start, a lot of trials waiting not only to start, a lot of trials also waiting to be confirmed by the Supreme Court. And as long as you don't manage to have a confirmation of a sentence that was given at the first instance, it's like the trial hasn't ended. So there are a lot of ongoing trials. And this is very complicated, because the accused died sometime before they get the confirmation of the Supreme Court. So it's like you did all this, but you just don't know what would have happened with the confirmation. Maybe they would be guilty, maybe not. So we don't know. And one of the what I consider an important also consequences of these trials, positive consequences of this trial, is the historical reparation they have, but not only for the direct victims, but also for the society in general. The problem is how do we involve the rest of the society? As I told you, the trial started a long time ago. We've been talking about the dictatorship for more than 40 years. So Argentinian people sometimes are just fed up to talk about this. This is a very political topic. So it's really difficult sometimes just to be able to bring it to another type of public. It's like, for instance, sometimes all the trials are public. Everybody can go to a trial and listen to it. All the hearings are public, but nobody goes. Nobody goes, and there is only one newspaper, but sometimes is doing an article about this. It's like there is a very big, as for me, a very big lack of visibility and interest of a trial, except the human rights community. So it's like the human rights community kind of feel everything is okay because everything is okay, except all the things I told you that are not okay. But they say, okay, the trials are ongoing, we're fine. But the problem is that they don't realize that many people don't even know the trials are still being done. And it's incredible for me. This really, the many people cannot even say crimes against humanity. Also, it's not so easy. It's not so easy to get to the rest of the society. And just to finish, I just wanted to show you something that also in my work, I work as a lawyer. I'm very serious. Also, I try to be very serious. But sometimes I also realize those things I was telling you, that nobody cares about the trials. Also, I care about it, the human rights community, the mothers, the grandmothers care about it. My friends doesn't care about it. So, not so much. It's like something we don't talk about it. And at some point, I got a little bit scared of this situation, but we were always the same people talking about it. And so with a friend of mine at that time, who is a writer also, we wrote a play to try to difundir, ¿cómo se diría?
Disseminate
the trial to another public, to show it in another place. And so we did it. We wrote a play, which sometimes is very basic and sometimes it's not. But we try to put some humor in this play, and it's called Cuarto Intermedio in Spanish, and it is called Court Adjourned in English, if we can say. We've never done it in English. But there is one thing I want to show you about this, and then I leave the floor to Karin. We were invited to do this play in the former clandestine center of detention, ESMA. So in the place where they were torturing people, the director of the museum is doing quite interesting things to open the museum to other persons that are not directly affected by human rights violation. And I think that he was with a London the Royal Holloway University of London. They prepared some program called Staging Difficult Past. And they invited us to show the play inside the former clandestine center of detention. And I want to share in one thing we do in the play is we ask people to come and act as if they were part of a trial. So there is a person who acts as the president of a tribunal, you have a victim, you have a prosecutor, you have a defendant, and this is what I wanted to show you now. How inside a clandestine center of detention, people could get involved, and because this is what we were trying to do with this play. It's to show people that they can get involved in this and that nothing will happen to them afterwards. So I'll just show some little parts of it. And first, I will show you this just to let you hear how people are.
Tenía así, digamos, para la época de la mencionó que era alto, fornido, usado.
First one. I want to show you the first one. So, sorry. I will try to hurry a little bit. Okay. I think it's this. Oh no, I did the same one. Sorry. Maybe it's this. Well, I'm not good. So I will just show you this. This is the trial.
Son un par de preguntitas nada más.
So this
Usted mencionó
girl
e hizo una descripción de
is acting as a judge.
fornido, usado, bigote. Le hago por dos características particulares. ¿Recuerda la edad aproximada que tendría?
This guy is acting as another judge. There are 3 judges. And he's eating a banana. Because sometimes you don't know, but in the trial, sometimes the judges just sleep, or just sometimes they drink some tea, or so they are the judges of the Argentinian criminal system. They're the same judges that condemn a little a 15 years old kid that robbed a cell phone, you know. So it's so we are here, we are in the clandestine center of detention. This is not a very funny moment, but I wanted to show you a funny one. So here is the. So people were very interested in participate, so they really come to participate. But I wanted to show you. Can you see? Please listen to this. De hecho, si se pierde. Did you listen to this? There are some people laughing, and we are inside the clandestine center of detention. So it was a big topic when we started to do the play, to wonder if what were we doing if we were allowed to make people laugh about it. And I will show you a last thing, and then I leave the floor, and I want to show you. Okay. I want to show you this. This is the play when we were doing it in a theater. So I want to show you the sentence of the ESMA trial. And I show you this part because it's subtitled in English.
Por favor, silencio. Se sientan, por favor, silencio. Por favor, porque tenemos que desalojar la sala, si no.
¡Silencio! Señoras y señores, les pido expresamente que controlen sus emociones. Caso contrario, me van a poner en la situación de tener que desalojar la sala. Motivo por el cual, ¡silencio! una palabra más y los desalojo. Entonces, si quieren escuchar, si están interesados en escuchar la resolución del tribunal, no van a tener otra solución que estar lo más callados posibles y controlar las emociones lo más posible. Muy bien, vamos a proceder con el acto.
So I just wanted to show you this for you to to see like how is the sentence for crimes against humanity. This trial lasted for 5 years, and it was a very tense moment at the end of a trial, and there was a lot of persons talking and singing inside the tribunal. So that's why the president of the tribunal asked people to be silent. But I wanted to show you this because these things, we don't see them on TV. Like for me, it's very special we are trying to speak about truth. We are trying to speak about, we are trying to make people speak, and we have the president of a tribunal asking for silence. So I think it would be very interesting to have more, if all those images, if all those moments that are very peculiar and very historical could have an access to other kind of people, and also to be disseminated more. So that's why we bring such kind of things, like things that really happen during the trials, to other people, just to make people know about what is happening. Not to tell this is good, this is bad, but just to make them know this is happening while you're at home, or while you're going to work, or while you're studying. And this is more or less everything I had to say. So I hope it was not too boring, and whatever you ask me.
No, Moni, that was super. Really, you put so many points on the table. But without further ado, I'm going to let Karine respond to you. I know we are running a bit out of time, but I would appreciate if everyone could stay some more minutes, because I think that it would be nice to allow people to also ask questions after Karine interpolates you. So Karine, down to you.
Well, thanks a lot, Clara, and for allowing me to participate, and of course, Monica, for this great presentation. I will be short because I really want to make sure that people can ask questions and participate. But I think, you really explain well the role of the international human rights law in the application of the right to justice and truth at the domestic level. And I think it's also a study case for those who work on prosecuting crimes at the domestic level, showing that prosecuting international crimes required expertise, specific expertise, and also collaboration between different actors, and a very specific strategic litigation. So I think that maybe one of my first questions to you, Enrique, is you explained that there have been so many trials in all the different parts of Argentina, and for instance, 4 trials for the same detention center, ESMA, and at the same time, the state created different units. For instance, as in the way that you work, this prosecutorial, the prosecution office, but also commission, to identify children who have been abducted. So there are different units and working together to know the truth, to prosecute these crimes. What does it mean in Argentina in terms of litigating this crime, building the litigation for these crimes? How was it organized to cover different periods, different centers, also different responsibility at different levels? Maybe you can tell us a bit more about that.
I think that it's not something that they had in mind very clear at the time they started the trials. I think that they started with the things they knew. So we know that ESMA started to to be a clandestine center of detention, and that was they started with what they knew already, who the accused they knew already. Then they tried to open the investigation to another crime, to other types of crimes, for instance, sexual crimes or civil complicity. They are trying also to open the strategy to civil complicity. It's like for instance, like there are some important trials for what Ford, the one that built cars, have done during the dictatorship, because I think they had a clandestine center of detention inside their fabric. I don't know how you say it, but you understand me. And they have judges. They also have sentences against judges that participated, but that were complice of the dictatorship. But we can say also that a big strategy is lacking. Also, I think that the work at the investigation level is done as best as they can, but it is still difficult for them to define a strategy. And many things that happened are also the product of luck. So suddenly, well, of course, you work, you try to investigate, and you realize that there was a clandestine center of detention that nobody knew about it. But it's not that you took the all the military system and you search in the military system who were doing what and when. And then from this, you can find out another clandestine center of detention. Many victims criticize the investigation because they feel that they have to bring information to the justice, and that justice is not doing all that they could. They do a lot. They do a lot, and they do a lot, and there are not so many people able to work on this. But here we have a difficulty, I think. I don't know if I answered the question.
Yeah, completely. And the need for the judiciary and the prosecution to work closely together for the prosecution of these crimes. And in all these crimes, civil society and victims are key to bring information and open cases. And in Argentina also, there have been a lot of initiatives on reparation. I mean, revealing the truth and prosecuting crimes are part of this preparation, but I understood there have been also some specific legislation on reparation. But what may be a bit less well known is how the judiciary, how this trial answer, the victim's request on reparation, how has been incorporated in these trials and in this strategy, and what will be the main remaining challenges for you on reparation?
No, I think from the economic point of view, there is no reparation in the trials, for instance. Never any victim is asking for civil compensation. The civil compensation is always goes along with the laws. But there are very, very few examples of reparation measure of reparation in the trials. Very few. I was trying to think about this morning because we've been talking, but I can't remember. I know about one case. I don't even remember what reparation measure they took. So it's very symbolic and very little. It's not incorporated in the way we are working every day. Not at all.
Well, that's very interesting. And I will have so many other questions, but maybe that's also why it's not so well known. I mean, reparation is also, a tool to make these events and justice and recognition better known and accessible for people. And I think you already answered my last point, where like you have been working so much on this prosecution of crime, and recently as well, you wrote this theater play, you wrote this very successful novel now in Argentina. You said that it was not well known and not well covered but what did you want to tell in this play, in this novel, that you cannot tell in a courtroom? Maybe it's more personal question, but I may ask it.
No, I think that in the courtroom, I cannot speak because it's the prosecutor. It's only the prosecutor can speak. Maybe it's because of this I need to express myself somewhere else. But no, what I feel is that the human rights community is really too exclusive. I can understand this also. It comes from a long history of a human rights community, how they built themselves. They had spies. Also, it was not easy, but at the moment, I think they really need to open themselves a little bit, because they're just communicating for the people who think the same as them. So this is, for me, a very dangerous thing to do in human rights. So if we all think that torture is bad and we all just stick together all the time, so we won't have any fight. We will all agree all the time. But the people who are torturing will be torturing. So I think really we need to open the language. We need to open the human rights community, I think, and also to try to escape a little bit from the political agenda, because otherwise we stick too much to a political party, and then it's like someone who is not from this political party will just say, what you're doing doesn't interest me. And it's like you don't have a chance to explain what you're doing. So I think that there's something interesting in Argentina, and I really think it's because, first, the human rights community sometimes closes too much, it's too much closed, exclusive. It's too much exclusive sometimes. If you're a direct victim or you have a relative who is a direct victim, it's easier to enter into the community. Otherwise, you're like a threat. So sometimes it's not easy to get to them. So and I think they don't even realize it sometimes. But it's for me, it's very important also to be able to. People are bored to listen to the same things for 40 years. So, and it's like, but it's not the same thing we're telling. So there are many things are happening that we're not only talking about torture and the clandestine center of detention when we talk about reparation. And so it's really difficult to open, to reach other public, if but it's really important for human rights to to strengthen themselves, to be able to reach them. I don't know if it's for me. Yes, for me it's. I think that the fact that I arrived to Argentina late, because I arrived in 2008, helped me to be part of a person who comes from. I'm a human rights lawyer, but I'm also someone from. I'm from inside and from outside at the same time. So I really can sometimes see this gap and this in the society. And I try to create links between them. It's only this.
Thank you very much, Monica.
So really, really fascinating tour through your life and your work, Moni, we are having here. So I would like to open the floor to the public. I don't know if anyone has a question. If you would like to speak and ask the question directly, please feel welcome to do that. No, if not, I will ask a question myself, but you can indicate here if you wish to talk. One question I have, Moni, and I think it connects to a very relevant issue, and is the issue about victims' participation and the right that victims have to participate. So I think I would love to hear your views on what that role has been in Argentina. I remember going with you, seeing you as querellante in Argentina in some of the trials, have a beautiful memory of that moment. But I would love to hear your reflections on that, because it continues to be one of the biggest challenges we face, not only in national trials, but also internationally, about the role of victims and their right to participate.
Yeah, in Argentina, victims have a right to participate, of course, as also they can be represented by a lawyer, they can bring evidence, they can give their testimony, and they do it. They used to do they do it. The problem is that sometimes after 14 years of trials, after some of them have given 5 testimonies in 5 trials. So they just sometimes say that it's too much, like they just don't want to testify anymore. So I think that there is a balance we have to find between the participation of victims, the important role of victims, but also give them the possibility not to be part of all the trials, and not to be the one that make the trials advance. And some of them are saying it, not all, because there's some. If you go before the court once and you tell your story once, it's okay. It's like you have to do it. You need to do it. Some of them feel repaired by doing this. Some of them don't feel repaired. Some of them feel worse because it's difficult for them to talk about this. It's difficult for them to remember those things. So the problem is that when justice depends on victims, I think.
Yeah, interesting to hear that. And it's indeed the situation, no? In many countries in the region, the querellante civil is the one that at the end of the day pushes the cases. Without them, the cases don't move. So you need to find the right balance. But it's a very good point. I have a question here from Sabine Mikolovsky, my colleague, who is saying to you, could you say a bit more about how the play was received, particularly by the human rights community, and what were their views on whether it is acceptable to deal with the past with humor? Great questions.
So I think we, thank you, Sabine. Hello, Sabine. No, we were lucky with the play. And I think we were lucky because even though we bring humor or we try to bring humor to this, it's not like we're making jokes on people or on the process or on victims. We're just trying to show some aspects that help or that we think that help other persons to get closer to the topic without having to so we all know about torture. So we all know that victims in Argentina were tortured, they were disappeared. This is something we all know. It's the only thing we've heard for 40 years. But now we want to talk about trials. So we have to show you how the justice is working. So we are showing people images of a justice system, images of the trials, sometimes images that we don't expect, but are far from solemnity. Sometimes we expect justice to be a very solemn ritual thing, which is true, but sometimes you can find a little thing that makes people look at the judge like a human person. So it's more easy to get to this story when you know that it's a story written by human persons. This is what we try to show. And for me, I'm very surprised, and I was very surprised when we did it at ESMA. I can see that maybe you couldn't see the video, and I'm sorry about it. But I was very surprised because they invited us to do it in the former clandestine center of detention. And I was scared. I was like, I'm not sure I want people to laugh in this place. But suddenly when people started to laugh, I said, okay, this is normal. It's okay. People are here. The director of the museum is a survivor of a dictatorship. She's a survivor of a dictatorship. And she invited us. And she went to see the play 4 times. So I really think that there is a place for humor, and there is a place for a language that is far from solemnity and far from repeating sentences that we hear every day and we don't even know what they mean. Like every day you can see the sentence truth, justice, and memory. And it's okay, I know about it because I work on human rights. But for someone who doesn't work on human rights, truth, justice, and memory can be really empty. So what we try to do is just to make this word not sound so empty sometimes. But for the moment, and survivors and victims and some, they have a lot of humor. They have. It's very nice to talk with them sometimes. Of course, it's sad. It's a sad topic and it's horrible. And but it doesn't mean that we have to be sad all the time. This is what I wanted to.
Moni, thank you so much for that answer, which I will ask one last question. I'm not seeing here more questions. And is this, were you told by any victim that they had a feeling of healing or reparation as a result of the performance? Is because art sometimes plays that reparative role, healing role, even if it's not itself legally speaking a form of reparation. What were the reactions? How did they feel it, the victims?
Well, the moment I prefer of a play is the moment of a trial, when people come into involve themselves. And I'm very surprised sometimes, because, for instance, I have in several cases, in several, we have a survivor acting as a defendant. I had a victim acting as a prosecutor. I had the video I wanted to show you. You had 2 sons of disappeared acting as judges. So I think, like, I don't know if they always feel this, but they decide where they want to be and what role they want to play. And this is really nice for me. And this, I think that there's something here that is very interesting. And I really like this.
And any statement you remember, any sentence that got your attention from a victim? What is the statement that you will not forget from a victim about what they felt with the play, being part of it or seeing it? Is there anything to recall here?
I will not answer this question with the play, but I will answer this question with reality. Okay. Because in one of the trials I was working, one of the witnesses that has to declare was a very important actress, an actress that used to play in comedies. She's very well known for a comedy. She's a comedian. And I talked to her with the phone before she went to the tribunals. And she told me, look, I don't like solemnity, so I'm very scared. I'm to have to declare to give my testimony. Her husband was disappeared during the dictatorship, but she had to give her testimony about the disappearance of her husband. And she was telling me on the phone that she was very scared of going to the tribunal because she doesn't like solemnity, and she was scared of being alone there and having to wait. And she was thinking that she would be willing to escape at that moment and so on. But when she came, she gave her testimony. And in the testimony, she said that after the disappearance of her husband, she couldn't act anymore in tragedy. So she started to act as a comedian. She started to do humor because she couldn't anymore be work as in tragedies. And I thought it was very interesting to think about the humor and this point of view, because I think it's one of the first time I was crying when I was listening to the testimony, because I think I don't know, but it's a question. Like, it's something we really wonder. I also know some victims that hate humors also about this topic. There was an Argentinian comedian who was on TV doing some parody of activists of the 70s this victim, she would hate it. She said she would just shut off TV and wouldn't be able to listen to it. So I think it depends more on the persons than on the. It depends on the level of trauma. It depends on the time, on the when this person have been able to start talking about this or not. And I think as much. So I said we have no time for the trials, that everything we're doing is too late. But I don't think that the treatment we give to the crimes against humanity is too late. It's like it's something we will still talk, we will still process during a long time, even though we're not able to do trials.
Super, Moni. And the last question Katia asks, and is related to what you've been saying, but maybe you can add some other things. The role of the arts is often so emphasized, is often not so emphasized in the world of human rights. What is the role cultural arts can play in helping our work? What are the obstacles and what more can be done in this regard?
Well, during the play, we talk about the trial of Nuremberg. And we say that in the trial of Nuremberg, there were a lot of writers, there was a lot of, there were writers as, that work on this, the filmmakers that worked on the trial of Nuremberg. And I'm always very surprised to see that in Argentina, there's not so much done about this. I think that our play is the first play about the trials. And the trial we're doing the trial since 14 years, and we are the first play about. So it's like, this is something that scares me a little bit sometimes, to see how difficult it is to bring those trials outside the tribunal. And I think it's a nice aspect to think about, the aspect of art, because the art is everywhere. So we're still writing books about the Second World War, so about the Nuremberg trial, about the genocide in Rwanda. I think it's fun. It's very important. I don't think that there is one way of doing it. I like the way with humor, but I don't think that it's the only way to do it. I'm not saying this is the way to do it, but I think art is necessary to process. It's necessary to process trauma. It's individual and it's collective.
Wow, and there you finish with a line to be remembered for the years to come. Art is necessary to process trauma. I think that packs it all wonderfully, Moni. And I think with that we will finish here. I could continue asking you questions. It's fascinating and again inspiring to hear you, Moni. To see what we sometimes don't see and to help us think about the challenges that we face in our daily work to make it really more effective, no? And to really transmit messages about why justice matters, why this cannot happen again, why we should construct other types of society. So I really ask people to join me to really thank you for your inspirational work, Moni. And I really hope that when you are back from your little leave now, you can come again to give a second round, another talk to us. And Karine, also, thank you, infinite thank you for your questions, for coming, and for all your support to Monica. I also think that in life is not only about people and dreams, but it's also about how we link to others and how they also help us to make those dreams come true. So thank you so much. It is very pleased to have you both here with us today.
No, thank you. I'm sorry for my English, but I will be better next time because I didn't sleep very well. But really, thank you so much, really. And I hope we can talk again soon and see each other.
Thank you very much, Clara.
Thank you so much.
Thank you to everyone. And Katya, big thanks to you and to Kat as well for making this possible. You as always.
Thank you. That was very enjoyable talk. Thank you very much.
No. And bye everyone and thank you for joining us until this late, but it was really special. So bye.